When Judge Aileen Cannon was first randomly assigned to oversee Donald Trump's criminal trial over his handling of classified documents, questions were repeatedly raised about whether she was the right judge to handle it. Beyond the fact that she was nominated by the defendant, Donald Trump, there was her relative lack of trial experience compared to other federal judges in the Southern District of Florida. Cannon had presided over just 4 short, relatively routine criminal cases during her tenure. Nothing remotely close to the complexity of a case involving felony criminal charges against a former president. Since taking the case, Judge Cannon's rulings have sparked even more questions among legal experts about the way she's overseeing it. Now today, a blockbuster, the New York Times reporting, indicates that those legal experts are not alone. Back when she was first appointed to the case, Judge Cannon's own colleagues, including the chief judge in her district, expressed concern about her taking the case. According to the Times, just after Cannon drew the assignment, 2 more experienced colleagues on the federal bench in Florida urged her to pass it up and hand it off to another jurist. Judge Cannon refused, which leads us to where we are today, with a case that has stalled indefinitely, favoring Donald Trump's defense strategy of delay, delay, delay. Joining me now, MSNBC legal correspondent Lisa Rubin. Lisa, thank you so much for being here. I always come to you with these Trump legal stories and ask you to contextualize just how big of a deal a story is or isn't. You were kicked back on your heels by this story.
I was totally kicked back on my heels. I got texted this story by a producer at our network earlier today, and literally I think I looked like the person in the Maxell commercials from the 1980s sitting back in their seat like this. And Alicia, here is why. The very fact that this story exists is almost as big of a deal as the fact that 2 different judges who are colleagues of Judge Cannon's called her up and asked her to consider removing herself from the case. And the reason is this: federal judges have lifetime tenure. They are generally perceived to be able to be secure in their jobs, and they don't talk about one another or their cases outside of school. This is akin to Politico's reporting of the Dobbs draft decision, or the New York Times' reporting last year about all of the consideration that led up to Dobbs in the first place. The fact that the justices had essentially voted among themselves to take the case, but concealed that from the public for a long time. The very fact that somebody wants to give the public insight into these processes that are happening behind the scenes, including the fact that 2 more senior judges are calling Judge Cannon and asking her to consider stepping back from the case, that in and of itself is a huge deal, separate and apart from the substance of the conversation.
Well, and let's talk about the substance of the conversation, because part of it was her relative inexperience, but there was also her ruling that made it seem as though there could be an appearance of bias.
Yeah, and I think part of what we're doing here is a little bit of a speculative dance, right? Sure. Because all we have is the New York Times' wording to go by it, and I don't want to parse it too closely. But it seems like this could have been a coordinated effort where the first judge calls and says, hey, we don't have a secure facility in Fort Pierce for you to review these documents. It would have to be constructed at great cost. Would you consider handing this off to a Miami judge, because there is such a facility there? When Judge Cannon says no, then the chief judge of the district, not nominated by a Democratic president, but by George W. Bush, calls her and makes it a little bit more plain. Hey, you had a rough time of it there when you handled the civil suit that was related to the Mar-a-Lago search, and essentially says to her, not, you're too inexperienced to do this. Maybe this would be better handled by a more experienced judge, but almost insinuates your prior experience with this case or something closely related thereto raises questions about your either competence, your bias, or both. That conversation is happening between 2 colleagues, both of equal stature, at least in terms of the law, is staggering.
Help me understand that piece of it. Just how usual or unusual is it for judges to have these types of conversations peer-to-peer?
I can't recall another situation in which a conversation peer-to-peer like this has been reported. The closest analog that I can think of is about 20 years ago, a judge here in Manhattan, in the Manhattan Federal Court, the Southern District of New York, had an expose published about him in the New York Times because he had sat on so many different motions in civil cases. There were nearly 300 motions on his docket that were more than 6 months old. And the Times did this reporting talking about the consequences to people who were litigants before him. In that reporting, the then chief judge of the district, Michael Mukasey, who then went to become the attorney general, said, look, inordinate delay is always a concern to any judicial district. Theoretically, Judge Cecilia Altanaga, the chief judge of the Southern District of Florida, shares maybe that concern, but it doesn't seem like that's what caused her to call Judge Cannon, because those conversations were held at the very outset of the case, not where we are now, where we have seen her propensity to delay.
Walk us through tomorrow's hearing. What are you watching for?
I mean, the very fact that the hearing is happening on a legal issue that has been litigated multiple times in different areas of the country, including with respect to then Special Counsel Robert Mueller, is itself surprising. She's going to have...
Which is the question of whether or not Jack Smith was unlawfully appointed.
Correct, under two different arguments. One about the appropriations to the Department of Justice, the other about the lawfulness of his appointment as an inferior officer by the Attorney General. She has essentially scheduled 2 days of hearings just on that argument and has also authorized 3 different non-parties, or what are called friends of the court, amici, to make arguments. I don't know that I'm familiar with any other case, let alone a criminal case of this importance, where amici are arguing in front of a federal district court judge an issue, albeit one of constitutional importance, but one that has been dealt with by multiple other courts before.
I'm not going to ask you about reassignment, because I feel like you and I get sort of end up on that cul-de-sac over and over again. So let me ask you instead about this. The New York Daily News reporting the Manhattan DA Alvin Bragg has been, quote, bombarded with death threats and harassing messages since Trump was convicted on 34 felony counts 3 weeks ago. Not surprising, still alarming.
Incredibly alarming, and the substance of the threats themselves is alarming. They're hateful, they're racist, they're recent, and they were all sent to him through his campaign apparatus. Theoretically, the NYPD is in possession of many more messages of that kind sent to Alvin Bragg's office or to his home. These are just sent to his campaign website. The New York Daily News doing some really blockbuster reporting tonight, showing us how much hate has been directed at the Manhattan DA just for doing his job, Alicia.
Lisa Rubin, MSNBC legal correspondent. Thank you, my friend, for being with us.